number 11, the petitions to Parliament Procedure Amendment Bill, National Assembly Bill number 51 of 2022, second reading.
Yes, the Honorable Ochien.
Thank you so much, Mr. Speaker. Mr. Speaker, I beg to move that the petitions to Parliament Procedure Amendment Bill, the National Assembly Bill number 51 of 2022, be now read a second time. Mr. Speaker, the public petitions is one of the very new and novel ways in which our new constitution made it mandatory to ensure that Kenyans are able to participate in parliamentary proceedings. They are able to ensure that their matters count the floor of Parliament, Mr. Speaker. Mr. Speaker, just like anybody can petition the High Court of Kenya today, any Kenyan can also petition Parliament in whatever manner, whatever form. Mr. Speaker, so this process of petition in Parliament has been going on since the new constitution came to be. And so the reason this bill was proposed was to just streamline that process, to streamline the way Kenyans engage with Parliament in terms of petitions, to make it easier for Kenyans to petition Parliament, to make it easier for Parliament to communicate with the rest of the world in as far as the petition is concerned, Mr. Speaker, and to ensure that petitions don't take so much time once they are brought to Parliament. Mr. Speaker, today, under our new constitution, anybody can petition the High Court or Supreme Court just by a letter. You do a letter, handwritten, then it have to be printed. You send it there, and they're duty bound to act on it. Yet in Parliament today, the way we've worked around receiving petitions, the way we've got around processing those petitions, makes it difficult for Kenyans to engage with the Parliament. And so this amendment, Mr. Speaker, is meant to ensure that the petitioners can approach this Parliament without undue regard to form and formalities, without due regard to so many things that they must provide to us. And that's why, Mr. Speaker, these amendments talk about having a standard form that a petitioner just goes to the website, fills it in, and brings back. Mr. Speaker, we are removing, Mr. Speaker, the requirement that the petitioner must provide so much evidence about what is petition in Parliament about. The only thing we are saying now that this new bill is that a petitioner just needs to tell us, is this matter pending in any court of law? If it is pending in court of law, don't bring to us the proceedings in that court. Just tell us the case number, and that will be sufficient. For now, we ask you to bring, the pleadings therein, the judgment therein. Now, what Parliament will require under this new amendment is just tell us what case number, in what court. Is it commercial division? Is it a criminal division? In which part of the country? And that will suffice, Mr. Speaker. Number three, Mr. Speaker, there are people who have been saying that, we should not, the clerk should not be the one communicating the petitioners. That the petitioners should be communicated to by the petitions committee, Mr. Speaker. Mr. Speaker, you can imagine if someone petitions Parliament today about flies, and maybe the petition is not done in the form required, or is not done in the manner that Parliament should look at it, why would a petition go to the committee for the committee to look at whether the petition is eligible or not? We as a committee of procedure and also rules of this House think that the clerk of the assembly should have some residual powers to summarily deal or communicate with the petitioners on matters where the petition does not meet form, where the petition does not, for example, disclose who is the petitioner. Why would the clerk take that kind of petition to the committee? If it's very clear to the clerk that this is a matter that is ongoing in court and what is being given to Parliament is not sufficient, why do you go to the committee? So we're still retaining the role of the clerk, because initially someone is proposing that the committee is the one that should communicate to the petitioner. Mr. Speaker, all the communication that comes from Parliament, even the committee ones, to the judiciary, to the presidency, because if they pass through and they are done under the hand of the clerk, not under the hand of the committee. And so we are retaining the residual powers of the clerk to communicate whatever decision that we make as a House or as a committee to the petitioner, Mr. Speaker. Mr. Speaker, the matters upon which anybody will petition Parliament are diverse. They are not one or two. They are as wide as the world is. And so what we are saying is that once a petition is processed and allowed to go through, then it now goes to the committee, and the committee alone cannot make the final decision on a matter under petition. So we are saying that once the committee sits and deliberates on a petition, the report of that committee will be brought back to this house, so that the matter of a petition cannot end at the committee. The committee says that, oh, we looked at this matter, and therefore we think this is the position that we take, and the matter ends there. Whether the committee of petitions approves or investigates, it must be brought back to this house, whether the house decides of the petition one way or the other. Speaker, the hallmark of this amendment, Mr. Speaker, is just to make it easier. And I want to tell Kenyans today that when this amendment passes, don't struggle with so many letters. Just go to the parliamentary website or come to Parliament. You'll get a standard form that has what you need to provide, that has a checklist, what you need to provide, and has down there a place where you sign and indicate to us your contacts. Then you submit it. You can submit it online. You don't have to travel to Nairobi if you are in Lodwar or in Ugenya. You submit it online. We'll receive it, process it normally, and get back to you on the address or the telephone number or the email you provided in that form. As simple as that. Number two, Mr. Speaker, we also want to make it easier for the Speaker of the Assembly to process these particular petitions. And that's why we are saying the Speaker should have a secretariat, an office here, where he will look at these petitions and is able to also communicate and tell the petitioner that, look, your petition was received and it complies with the rules, and it has been, committed to the relevant committee, without having to go to the committee to come back and then say, oh, we've now received. There should be at least a proper back and forth feedback mechanism that help us do this, Mr. Speaker. Mr. Speaker, the committee on House Rules made a couple of amendments to the bill to make it easier, and therefore we are going to modify one of the amendments that require that the petition should only include the case number and the name of the court, like I've said. We will maintain the clerk's role in looking at the admissibility and compliance with the rules as required. Mr. Speaker, we will also retain the existing timelines, because again, we cannot have petitioners coming in and the petition staying here for so long without being looked at, but also we can also not limit so much the time that Parliament has to deal with petitions, and that is dealt with, Mr. Speaker, in this. And the clerk is then duty bound to communicate the petitioner at the time when the petition is accepted, at the time the petition is processed, and the decision of the House on the petition. So, Speaker, we believe that with this, it will be very easier for Kenyans to engage with this House in as far as the petitions are concerned. And, Mr. Speaker, let me conclude by thanking and extending a hand of gratitude to the Office of the Clerk, the Office of the Speaker, in ensuring that this bill is processed as quickly as it has been. Mr. Speaker, I beg to move and request Honorable Murugara, my senior, to second. Thank you.